We now move on to the last part of the module of a bit of a reflection on the Indian waste management law. I single out soil waste management law for our detailed consideration. There are quite a bit of elaborate provisions made with regard to plastics management. There are regulations made in relation to construction waste management. There are regulations made in relation to the use of fly ash in as construction material under that law. But the focus now, and with the time available at my command, I will confine to a discussion on the most prominent of all the wastes, both in terms of volume and in terms of the inconvenience that's caused: solid waste management. What does the law say? How does it work? And what results it obtains is what is our inquiry here. Solid waste management law. Waste, as you know, is primarily a state subject, managed and administered at the local level through local self-government institutions as part of their mandatory functions of management. You may recall, while discussing about the role of the local bodies in environmental management, we had referred to one important case. And let me recall the case of Ratlam Municipal Corporation versus Vardhi-Chand, decided by the Supreme Court in 1980. In this Vardhi-Chand case, the Supreme Court recall that the municipality has the function of managing waste, of taking care of the health, hygiene, and well-being of the local communities, proper maintenance of drainage systems as a non-negotiable function of it, for which budgetary constraints cannot be an excuse to enable it to escape from fulfilling the obligation. Even today, the primary obligation on local bodies, even with all the changes that has come in the law, remains intact. Let me re-emphasize here the local body's role as constitutionally ordained and as has been reverberated through this judicial pronouncement of 1980 remains the same even now with all the changes. What you have in the changes that has come in the law, or the additions that have come in the law, are essentially to act as props and reinforcement of the local body to perform this function to the fullest in the most effective way. It's very interesting to note that although this is a state subject and it is invariably been part of the local laws of the states, the Ministry of Environment, Forest and Climate Change got into this act of lawmaking in the year 2000 and effecting a number of modifications and amendments to that law as recently as 2018 and 2019. And why did it get into? For the following reasons. Number one, to strengthen the local bodies to perform this function by bringing in the State Pollution Control Board into the scheme of things. It was not there earlier. This role was not there for the State Pollution Control Board. Now, this is a major actor now. To infuse the management of this waste with specialized knowledge and expertise, which was lacking in the municipalities and other local bodies. Second, to address a host of environmental related issues. Since this has environmental implications, if they are left unattended to or allowed to pile up, impact on health, hygiene and environment on account of increasing volumes of their production, they're getting mixed with a host of other varieties of waste, littered, left unattended to, without anybody made responsible for its disposal or held accountable for its generation and mishandling. But it's not something which the ministry did it by itself. Actually, the entry of Environment Ministry became inevitable. mainly because of, once again, interventions of the higher judiciary in a number of cases. The higher judiciary, as you would have guessed, berated the state for poor handling and management of the issue and required it to have a greater focused attention to the problems arising from its generation, collection, transportation, and disposal, and to infuse expertise in addressing the complexities of composition and varied impacts of the waste generated by the current consumerist society. Each word is important for you to note. That in a few lines encapsulates the evolution of the law and its working. To make it a little bit more clearer, I refer to the three major cases which actually illustrate the point made so far. Once again, I get back to the case of B.L. Vadhera versus Union of India, 1996 Supreme Court judgment, a petition on public interest about the pathetic state of waste management and insanitary conditions of Delhi. The Supreme Court reiterates the ruling of the Ratlam case by holding that the municipal bodies had statutory obligation to clean and scavenge the city and to ensure proper collection, transportation, and disposal of solid waste. It just did not state that and leave it at that. The Supreme Court took pains, of course, very much well supported and assisted by an expert committee constituted for the purpose, and picking the major recommendations from it, it fashioned out a set of directions for proper management of waste. And as it always happens, as it always happened in India, Supreme Court orders, when the orders are given, people fold their hands and submit before the court that they will comply with that. But once the judgment is over, once the court's attention is taken out of this particular case, it's business as usual. These instructions were hardly adhered to. Close on the heels of this case, and there were quite a good voluntary organizations and individuals of very great unimpeachable quality and character. And that's one thing great with our judicial process with regard to environmental management, I must say. Such people have been the real triggers for reforms, both in the law and in their working, and this is amply manifest in matters concerning waste management. Another writ petition before the Supreme Court, and what did the Supreme Court do? The Supreme Court went a step ahead, and considering this case, it is not just one case, a series of cases and orders. It's almost like bombarding the government and authorities for their inaction through a series of writ petitions and series of orders issued by the higher judiciary. In just about 2 years' time, issued a series of orders that constituted the very core aspect of waste management law, subsequently made by the central government. What I'm referring to is a very important case, Almitra Patel versus Union of India. A frail-looking lady, an engineer by profession, who had nothing to do with court or courtcraft, took upon herself with missionary zeal of alerting the local administration, of making the state governments understand their problems, of managing waste, and then through the courts of law, really engaged them in an exercise of cleaning the streets and improving the quality of our lives through waste management law and its working. In the series of orders issued by the Supreme Court in the host of cases of Almitra Patel, one of them, the Supreme Court constituted an expert committee, and this committee went into the different aspects of municipal solid waste management. A very detailed report was submitted. The highest court was very happy and picked 10 major recommendations In addition to whatever recommendations and instructions that were issued in PL Vadera's case, 10 additional directions it issued. And to give a little bit of an idea of them, these included strict prohibition of waste dumping in streets and public places, and its enforcement by imposing fines and charges for collection and safe disposal of such waste by the authorities, and then to adjudicate upon violations, requiring the local bodies to appoint magistrates, regular and periodic washing and cleaning of streets. Significant set of suggestions, something which the local bodies ought to have done, something which the state government should have taken note of and acted upon. But since that was not done, it became, according to the Supreme Court, its own duty to remind them their duties and also giving them instructions to perform them. It also said there are a number of suggestions made by this expert committee for safe disposal of waste. Observe them. Revenue authorities should have to henceforth identify and make available sites, no excuses, and at no extra cost to these authorities with due consideration of environmental implications for safe disposal and for setting up of compost plants. Space for that. Measures to be taken for prevention of encroachment of public spaces and creation of slums, and to put into effect all the directions of the court in a time-bound manner. The court, for the first time, brings in the expert and professional in the State Pollution Control Board. Actually, this is court's intervention. Till the court came into this act of insisting on the engagement of an expert body or a professional body called as the State Pollution Control Board, the government never thought about that. I am referring to the situation in 1998. Till then, the Environment Ministry did not bother about that. It was all local bodies' work. But now the court says all these local bodies need have to report and then get ideas from, advice and guidance from the State Pollution Control Board on the schemes of waste management by reporting actions and compliance, and get their advice from time to time. This actually led to the crafting of the Municipal Solid Waste Management Rules of 2000 by the Environment Ministry at the center. This was recast and thoroughly amended to, look at the title, Solid Waste Management and Handling Rules. Municipal Waste to Solid Waste Management and Handling Rules in 2016. There is a clear shifting of gears in the approach to and the management of municipal waste. You can discern. Now it becomes a more organized, professionalized, elaborate, and a well-planned venture. The Municipal Solid Waste Management Rules, MSWM rules, becomes a beehive covering a host of activities from the cradle to the grave of the waste and even thereafter. What does it include? Generation, storage, collection, segregation, transfer, transport, processing, and disposal of solid waste in an environmentally compatible manner by adopting the principles of economy, aesthetics, energy generation, and conservation, and observe the ground rules of safety and security. So this in gist would give you an idea of the law that was very rudimentary, left only to the municipal bodies to handle it in an amateurish way, to something highly professionalized. Look at the municipal solid waste management value chain. It includes primary collection and transportation, door-to-door collection, secondary collection and transportation, transport to bins from where waste is lifted and transported to either transfer stations or processing facilities, then transfer station and processing site, and then ultimately to the disposal site. Clear rules. and responsibilities are assigned to different agencies of state to carry into effect different aspects and stages of waste management, from the local body to the revenue administration and then to the state pollution control board. There are clear stipulation of duties, responsibilities and obligations prescribed for waste generator, manager at various levels in the value chain. Penal sanctions and actions for violations add teeth to the regulation. So, the municipal solid waste management regime has transformed over a period of time into a modern technology-driven venture. And in 2016, with the launch of a web-based application, integrated waste management system that collects information and assists in coordinating waste generators, recyclers, operators of disposal facilities and state agencies, it has become tech savvy as well. In 2016, with this measure, the ministry ushered information technology into the municipal solid waste management scheme of things. The other shift is of bringing in public-private partnership, and through this, within this particular management regime, engagement of independent and professionally equipped contractors to operate at different stages. The venture has now become an industrial activity, generating employment and expanding the scope for gainful engagement of professional consultants also. And from 2016, the management focus has expanded to solid waste and not just municipal solid waste. Look at the nomenclature. The change is essentially with the object of closing every possible avenues of an escape route for anyone from liability under the nomenclature of the waste generated or dumped by one is not municipal waste. Many a time, you will not be able to characterize something as a municipal waste as the restrictive definition gave. And thereby, heaps and heaps of solid waste remained with nobody accounting for it or made accountable for it. And so, we have an expanded definition of solid waste, whether it is the municipal area or in the rural area, in the city, urban or rural, it does not matter. Solid waste is solid waste wherever found now. Under this law, the grip of the law enforcer is tightened over the wrongdoer. It now mandates waste segregation at source. The idea is scientific also, to channelize the waste to wealth by recovery, reuse and recycle. Because if you segregate at the source itself, subsequent segregation, which requires a lot of manpower and a lot of effort and energy, is reduced. And so when you segregate at source and making it mandatory, we are actually achieving two things. It's both economic, scientific, beneficial. Collection and disposal of sanitary waste in a more responsible way by the manufacturer, brand owners and generators. What is the obligation? They have to create awareness about use, but they also need to provide for pouches for safe disposal. It applies extended producer responsibility principle for the disposal of non-biodegradable packing material. Very, very important. Thereby, it makes provision for collection after use and its disposal by the brand owners and generators. Empowers local bodies to levy user fee on bulk generators. This is very much required. Service charges you can collect. And so, the waste collector can collect the levy that has been imposed for collection, disposal and processing. Spot fines can be imposed for littering and non-segregation, and the quantum of which will be decided by the local bodies. So, waste disposal, as a general rule, is made a primary obligation on site of generation. So generator primarily responsible to dispose of the waste generated by him on his site in an environment friendly way. And primarily, biodegradable waste should be processed, treated, and disposed of through composting or biomethanation within the premises as far as possible, and only the residual waste shall be given to the waste collectors or agency as directed by the local authority. This has to be noted carefully. This also provides for a central monitoring committee constituted for this purpose under the chairmanship of the Secretary, Ministry of Environment, Forest and Climate Change. What do they do? To monitor the overall implementation of the rules. With a minor few changes to this law made in the year 2016, in 2019, even informal waste pickers are brought into the mainstream of waste management. The developments on paper, as I have just mentioned with regard to the other kinds of waste, very, very laudatory, impressive. Unfortunately, the situation at the ground zero appears to have neither taken cognizance of the legal evolution nor compulsions of the time. This is the most saddest part. Besides inadequacies in the required skills in effective monitoring, regulation, implementation, and execution by the concerned, in addition to poor coordination and cooperation amongst the various agencies of state, the continued irresponsible business practices and user attitudes, me and you, besides corruption, have exacerbated the problem of the solid waste management. Higher judiciary and the National Green Tribunal have been reminding, have been cautioning, have been reprimanding the concerned all the while. High time. Actions are taken at all levels by everyone in a concrete, concerted way before it reaches a cul-de-sac, a point of no return. This concludes our ninth module, and from henceforth we move on to justice dispensation, as to how it evolved, as to how it contributed to environmental management and what is its current state, as to knit together all the inquiries and discussions that we had on different aspects of environmental law so far, as a culmination of a major exercise in learning about environmental law, both at the domestic and at the international level.